Hello everyone. Today I will be talking about the recent verdict given by the High Court in regard to banning hijab in Karnataka's educational institution. So this debate over the hijab is basically a head scarf worn by a Muslim woman. This particular debate over wearing of hijab or allowing hijab inside the educational institution has caused a standoff at a women's college in the southern Indian state of Karnataka. So there were six teenage students at a government-run pre-university college, which is equivalent to a high school, have alleged that they have been barred from classes for weeks because they insisted on wearing hijab. Now, this college said that it has only asked the students to remove the hijab inside the classroom and they can still wear that hijab around the campus. So, what reason the students gave? Students gave that we have a few male teachers and we need to cover our hair before now. So that is why they are wearing hijab. Now, all this debate started in regard to a controversial notification that was issued by the School Education Department of Karnataka under Section 133, Subclause 2 of the Karnataka Education Act 1983. In this particular act, there is no specific reference to the hijab in the notification. So it's a vague language and it covers that it is being restored to by certain pre-university schools to single out hijab wearing young girls and to deny to them the right to access education. So the objective of the notification is for schoolgoers to wear clothing which protects the equality, integrity, and does not hinder with public order. So this was in short the clause, the provision which led to all this controversy. So after this controversy, when students were not allowed to go inside the class to attend their school, they went to the judiciary. So the case which we will be discussing today is about Resham versus State of Karnataka and Others was with connected case. So on 15th March, a three-judge bench of Karnataka High Court, which comprised of Chief Justice Ritu Raj Avasti, Justice Krishna S. Dikshit, and Justice J. M. Kazi, they gave a verdict on the petition related to banning hijab in Karnataka's educational institution. And the court gave the observations. The following observations were given by the court. One of them was that High Court upheld the order of Karnataka government prescribing wearing of uniforms in schools and pre-university colleges as per the provisions of Karnataka Education Act 1983. So the court rejected all the petitions filed by 9 Muslim girl students to the Udupi district. Then High Court also ruled that wearing of hijab by Muslim women is not a part of essential religious practice in Islam. And thus, the right to wear a hijab is not protected under the right to freedom of religion guaranteed by Article 25 of the Constitution of India. The High Court also declared that prescribing uniforms for students neither violates their right to freedom of speech and expression nor the right to privacy guaranteed by the Constitution. So finally, the court held that banning wearing of hijab in educational institutions is a reasonable restriction which is permitted by the Constitution and students cannot object to the ban. So this was held by the High Court, by the Karnataka High Court in regard to this case. But after the Karnataka High Court judgment, a Muslim student from Karnataka approached the Supreme Court against the order. And in her plea, the student mentioned that right to wear a hijab is protected by the right to conscience under Article 25 of the Constitution. Recently, a 66-year-old social activist has also moved to the Supreme Court of India against the Karnataka High Court judgment. The petitioner herself is a hijab wearing woman and has submitted that she wasn't given a chance to be heard by the High Court, and thereby this act of High Court violated her right arising out of principle of orality, and further in her written submissions were also not considered or adverted to anywhere. So a special leave petition has been filed by her through advocates Talha Abdul Rahman, Muhammad Afif, Basawa Prasad Kunale, M. Shaz Khan, and Harsh Vardhan Kedia. So now the matter has went to the Supreme Court, so we need to wait and see what the Supreme Court has for this case. I hope this video was helpful to all of you. Please do like, share, and subscribe to my channel. And in case you have any query in regard to legal matters or law exams, you can reach out to me on my Instagram ID or on my email ID. Link for the same is provided in the description below. Thank you very much.